Good afternoon, this is Peter Towers from ESS BIZTOOLS. Welcome to this webinar where we're going to look at, on a broad basis, the type of services supplied by ESS BIZTOOLS to assist accountants to deliver business advisory services. And in particular, our educational feature today is looking at some of the court case decisions and actions of liquidators relative to the Personal Property Securities Act and the Personal Property Securities Register. Those of you who have been at the AEST conference in Melbourne this week, it was a very interesting event, and I hope you've returned to your homes and to your offices safely and are now getting back into the work. Those of you who weren't there missed something, and we're going to comment on the AEST conference in our webinar next week on the 29th of October at 12 noon Australian Eastern Daylight Time. So it's a webinar that's looking at the products and services within ESS BIZTOOLS, but also we'll have an overview of the AEST conference because there were some very interesting discussions about where accounting is headed, particularly the input from Jeff Leeper, Deputy Commissioner of the Australian Taxation Office, who had some very interesting comments to make. If you have any questions whilst we're going through the webinar, can you please type them and in webinar jargon, raise your hand, and I will answer the questions as we proceed during the webinar. So first of all, this is a quick overview of what's contained within ESS BIZTOOLS. The product has been developed around papers or articles. There's over 500 of those that are targeted at small, medium enterprises that are there for accountants to use in various methods. We have developed business advisory services which has two key components. The first one is 13 modules to help an accountancy business prepare itself to start offering business advisory services. Our recommendation is you work through a module a week, so it will take you about 3 months if you do it once a week. An hour to 2 hours a week is a great way to get the team ready to understand the importance of this product. And in that way, you will be able to develop a product that will enable you to earn substantial fees. And the comments that we're going to make next week on the 29th of October about what the tax office spokesman had to say on Tuesday will, I think, really highlight to you the necessity to develop a firm business advisory services policy now rather than waiting for when the tax office are expecting a substantial reduction in earnings of accountancy businesses, which they're foreshadowing will occur in 2015-16. More about that next week on the 29th of October. Also part of business advisory services is 15 modules on products that are pre-prepared, ready for you to use to earn professional fees, preferably after you've completed the introduction training with your team, so that you are able to start earning fees from delivering those services to your clients. Business Plus is a newsletter we produce each month. We've been producing it for 7.5 years. There are 13 editions each year, none in January, but two extras in May, one on the federal budget as it affects small medium enterprises, and the second one an end-of-year tax planning checklist. We upload the newsletter to our website on the second Friday of a month at 12 noon Australian Eastern Standard Time, and it's then available for our accounting firm subscribers to badge it with their names and send it to their clients. Client mentoring and coaching is a collection of articles which we've configured into 12 modules to assist in educating clients on the type of services that you provide to them. We don't believe that you can sit back and assume that your clients know that you are supplying a wider range of services. You have to promote and market that to them. One of the easy ways to doing that is to send your clients some material so they have a better idea of what some of these products and terminologies are all about. Leadership modules, some subscribers claim this is our best feature. It includes 8 modules written by Peter McDougall, ex-colonel in the Australian Army, principal of Leadership Academy. The material has been prepared for accountants to use, first of all with your own teams, to make sure that the people who are going to be involved in the presenting of business advisory services as part of you offering a virtual CFO service understand the leadership responsibilities of that role. And then if you wish, you could utilize the 8 special modules in leadership as products to sell services to your clients. Some of our subscribers are doing that quite successfully. Client seminars are seminar webinars pre-prepared, ready for use. There are 34 of them. They vary in time schedules from 1 hour through to 15 hours, not 15 hours straight, of course. They've been configured into 5 sections of 3 hours, those ones. The most popular ones these days are the 1-hour seminars, but some of our subscribers still use the 15-hour seminars a couple of times a year. And we have ESS Biz Grants, which is our associated product that assists in identifying government grants for small, medium enterprises. It's been streamlined. We released the new version about 5 weeks ago, and it significantly speeds up the processing and analysis of grants for you to talk to your clients. And grants are very important. SMEs like the idea that they can receive government grants. The government will be announcing the new Commercialising Ideas grant in the next few days. There are rumours now that it's going to be an amount of up to $1 million on a 50-50 basis. So if you have clients who have developed new products, services or technologies, this could be the grant for them. Hopefully we'll know more details by the 30th of October, because that's when our next ESS Biz Grants webinar is on at 2 p.m. Australian Eastern Daylight Time, 1 p.m. Australian Eastern Standard Time, and the feature is looking at the new research grants that the government has released. So that's the overview of ESS BizTools. I'll just close that down, and the feature of this webinar today, and we try in these educational webinars to highlight key things that are happening, is a continuation of the webinar we ran about a week and a half ago on the Personal Property Securities Register. We believe that this is a very important area that somehow or other has fallen into a bit of a no man's land. It's not fully a legal issue, it's not fully an accounting issue, but some of your clients are potentially going to suffer enormous financial consequences of being unaware of this legislation. I still have great difficulty in understanding how this legislation was ever introduced into Australia. It seems very unfair to me that the person who paid for an asset could lose it because they were unaware or didn't think it was important enough to register on a government register. But nevertheless, it's the law. And we believe that accountants have a role to ensure that their clients, your clients, are adequately prepared and understand how this legislation is working. So today's feature is to have a look at some of the court decisions that have already emerged under this legislation, and to look at also at some of the actions that are attributed to liquidators and administrators in following through on this legislation. Obviously, they're acting for their clients, normally the secured creditors. So just to recap, there's already been millions of dollars lost under this legislation in Australia, caused by ignorance. People are just not registering. We believe that every business should be determining the amount of financial embarrassment that they might be prepared to accept. Now, someone at the AEST conference told me he doubted if he'd have a tolerance for more than $500 as a financial embarrassment, because I'd suggest to him a minimum might be $5,000, but in some businesses it could be $50,000, and in others $100,000. But that was his answer, and he thought most of his clients were the same. He then admitted to me that he hadn't done a due diligence review, and I think he was going back to start that process to occur in the next couple of weeks. And the second one is not registering. I believe part of the confusion on this PPSA Act is the fact that it is voluntary to register. And I believe that that, combined with the name, personal property, has caused a lot of misunderstanding as to the effects of this legislation on businesses. And it's not just small, medium enterprises that have been caught out under this legislation. There's been some major problems to the big end of town from this legislation, and there's rumours of another major issue. It's been written up in the Sydney Morning Herald and some other publications relating to Forge. There is a $50 million group of assets that have been supplied to Forge by a company that, according to the administrators, have not been registered on the PPSR, and an insolvency event has occurred. A court has been asked to make a ruling on that. But how would you feel if one of your clients was caught in that situation of losing an asset? And it's no use saying we're going to look at it in 3 or 4 months' time and try to fix up an issue if it becomes obvious then. There are very strict deadlines on registrations on the PPSR. For inventory, registration needs to be made prior to the grantor, the customer, obtaining possession. So you obviously can't go back 3 or 4 months ago in 3 or 4 months' time to fix up something that might be occurring now. For non-inventory, which is supply of assets that might have a retention of title clause on them, a RMAPA type clause, within 15 days. But we're going to refer a little later to a comment from a liquidator. Please stress to your clients that the RMAPA clauses that they had in operation prior to January 2012 are probably completely ineffective under this legislation. They needed to be redrafted from January 2012. And you have 15 days to register that type of transaction if you're just starting it with that particular client. And other security interests, which could relate to the an agreement on the use of the business's intellectual property, for argument's sake, with another entity, or it could be loans being made. Those type of transactions have to be registered within 20 days. I'm sure you know you don't have to register every transaction, but you need to register a different transaction and then make sure that if there are any variations in the way your client is dealing with a particular customer, or where they are placing assets, that those changes are looked at and considered to determine whether a new registration needs to be made. So our recommendation is that accountants should be encouraging their clients to see a commercial solicitor to make sure they have appropriate terms of trade agreement and retention of title agreements, and they may need more than one set of those agreements if they have different types of products or services or arrangements with different types of customers. And then we believe it's an accountant's role, because I can't imagine too many solicitors doing this, is sitting down in your client's premises using a due diligence review list to ensure that every type of transaction that your client's getting involved in is being examined to determine whether it should be registered. And that's when the big question comes in as to how much money your client is prepared to lose through non-registration. What is the degree of their financial embarrassment? And if it's only $20,000, well, any event that was going to create a problem in excess of that, I would suggest should be registered. But it's too late to wait to next year. A number of accountants have been saying to me, oh, we'll do it next year when we're not as busy. Well, that's okay as long as there's no incidents going to occur to transactions which are occurring today. The problem might be occurring now. And you wouldn't want to have that conversation with your client, would you? That the client had lost out on non-registration. So let's look at some of the problem areas that are occurring from court cases and liquidators' actions. Inventory is a big problem. Where the collateral is inventory, the security interest must be registered before the customer, who's called the grantor, obtains possession. In one instance, in Queensland, a franchise that operated in about 10 different locations had a significant amount of stock supplied on a consignment basis by about 30 suppliers. The business got into difficulties. A liquidator was appointed. I understand that about 27 of the 30 suppliers had not registered their interests on the PPSR, so the liquidator was able to seize that inventory and sell it for the benefit of the secured creditor. You wouldn't want that to happen to your clients, I'm sure. Heavy moving equipment is another case that went to the Queensland Supreme Court. The equipment was owned by one company in the group, the asset-owning company, that had then rented it or hired it to another company, which was obviously the trading entity. No registration was made on the PPSR. The trading entity had obviously borrowed money from a bank and got behind in payments, and a liquidator was appointed, and the court agreed that the liquidator could seize assets worth about $2.2 million and sell them for the benefit of the secured creditor. Another case involves a water tanker on dry hire to a mining company in Western Australia. The water tank was a vehicle, therefore it had a serial number and required registration under the 90-day rule. Incidentally, the House of Representatives has passed legislation to abolish the 90-day rule and make it 12 months like other assets that have been hired or leased. But that legislation has not yet been passed by the Senate. And I don't know how long it's likely to go before it gets passed by the Senate. The Senate don't seem to be keen on making decisions at present. So the liquidator seized the water tanker and has sold it for the benefit of the secured creditor. So the original owners, the people who had taken on a debt to buy this water tanker, no longer have an asset. It's been sold to someone else, and they still have the debt for the money they borrowed to purchase the water tanker in the first instance. Not a very pretty picture for a client to end up in. There's been reports in the marketplace about preferential payment situation. I'm aware of one. It's a cabinet making business, partnership of husband and wife. They made a number of kitchen suites, high quality ones, for a display housing village, and agreed to rent these to the developer for a period of time, and then they were to be paid out in about 18 months, presumably when the houses were sold. The developer obviously got into financial difficulties. A liquidator was appointed. The developer had been paying lease payments or rental payments for the kitchens. The sum of money was $172,000, and the liquidator demanded a preferential repayment of that amount. I understand the business wasn't able to fund that, and the business no longer exists. Clothing equipment and product supplier. A clothing equipment and product supplier thought they'd done the right thing, but they used an inappropriate terms of trade agreement and retention of title agreement. They used documents that were drafted prior to January 2012, and that didn't give them protection. They thought that by having some wording on the bottom of their invoices that they were complying with the legislation. That is not the case. Invoices are post-transaction. The terms of trade and the retention of title agreements need to be signed prior to the transaction, so that they can be registered on the PPSR with in the deadline time. There's been another case involving trucks and trailers. The business hired trucks and trailers with a market value of $1.4 million. The court found that the suppliers regularly engaged in the business of leasing goods, and hence the hire agreement was deemed to be a PPS lease. The hiring business did not take steps to perfect their security interest, and that means they didn't register it on the PPSR. Liquidator was able to seize the trucks and trailers and sell them for the benefit of the secured creditor. That case did not involve a big business. The hirers were not a big business. And this type of situation that could occur to a whole range of small, medium enterprises. The on-hiring of goods has also caused some problems. Company A hired goods to Company B, and in their terms of trade prohibited Company B from on-hiring any of Company A's products, equipment. However, Company B on-hired that equipment to Company C without Company A's written authority. An administrator was appointed to C, and now there's a fair bit of legal skirmishing to try to sort out the position. I think the moral of this is that if you have clients who are hiring goods, especially to other companies, there needs to be ongoing due diligence to ensure that if the business that has been doing the hiring, in this case Company B, hires them to anyone else, that they lodge the appropriate registrations on the PPSR. The feedback in the marketplace from the hiring industry is that many people participating in the hiring industry have lost a fair bit of money, sums varying from $25,000 to $85,000, I've heard, because of non-registration on the PPSR. Preferential payments in general, I've mentioned them. They are a situation for many businesses. If they are registered, so if someone has got a terms of trade agreement and a retention of title agreement signed and registered on the PPSR, there's basically no action that liquidators can take. It's when they're not registered that liquidators are then able to commence this claim for preferential payments. I think it's worth looking at, again, those of you who participated in this similar webinar 10 days ago would have already seen this, but I think it's a very important comment from Darren Vardy, an insolvency practitioner who participated in one of our webinars on this subject about 6 weeks ago. As an insolvency practitioner, quite often we are faced with suppliers who have retention of title clauses. They've got remarpa clauses in place, but are not aware of the changes in the security regime effective in January 2012. This lack of awareness amazes me and is predominant amongst small businesses. Unfortunately, the business owner generally finds out the hard way when faced with an insolvency practitioner who tells them that they no longer have the title and ownership of the goods. So what can you do about this? We think you should be conducting a due diligence review now, and we will show you some templates that we have developed within our system that we hope that you might be inclined to utilize. We've surveyed some of our subscribers who are already using these tools. One gave me this feedback. Out of 10 clients that he's used the system on already, 1 knew something about it, 1 had read about the PPSR, 8 knew nothing. The other important thing that I probably should have put on that slide is the 10 of them had done nothing about it. And the accountant said most of them probably should have. So accountants can assist by utilizing the product we've produced as part of our overall product range. We call it the PPSR due diligence system, that you can undertake a review of your clients to find out where they have the weak spots that they could be registering. Time taken to undertake this task in general will be 1 to 3 hours. I have had feedback that one took nearly 8 hours. The client had a lot of different activities going on. And the practitioners are charging $350 to $400 per hour plus GST to undertake the review. Quite frankly, I believe if the client declines the review that you should be indicating to them that you are sending them a letter and get them to sign a letter to indicate they've declined the review. Because the problem with this legislation is that a time bomb could be ticking away, and an insolvency event hopefully will never occur for any of your clients, but it could occur in 4 or 5 years' time. People will have very poor memories by then. They will forget that you alerted them to the problems under this legislation, and the way to protect yourself is to have a signed letter from your client if they do not wish to undertake a review of their situation. We have a special promotion on for this month, or for a month going through to mid-November, on the personal property securities register. We normally sell it at $385. We're selling it at $299, including GST. You can go straight to the ESS BIZTOOLS site to sign up, and we're going to go and have a look at that in a moment. Or you can receive it as part of the ESS BIZTOOLS Gold package, which is $2,970 for 12 months, 24/7 access, including GST, and the PPSR due diligence package is part of that. So we'll just close the PowerPoint slides down, and I'm going to go on to the ESS BIZTOOLS website, and to get where we've got to go, we go into products. We're not going to look at anything else within ESS BIZTOOLS. The purpose of this is just to go into business advisory services. This is the products that help you get ready on the left-hand side. This is the actual products on the right-hand side. We're going to go to the Personal Property Securities Register. We have with all our material, we have an executive summary or a précis first to tell you what's in it. So I'm just going to go through that, and we're going to download it so you can have a look at how this system operates. Don't forget, if you have any questions, please type them out and raise your hand. So that's a list of all the material that's in it. We have a procedure control form for every one of our products, which makes it far easier to work through. The double lines on any ESS BIZTOOLS material means that it's the space left for you to badge the product with your logo, a name, an address, and anything else you want to put on it. So this is the form you would set up for the individual clients. You would download it into your hard drive so you can file it in the client's file. It has linkages to papers that we have written on the personal properties securities legislation that you can flick to read. There are forms that will assist in the preparation of a quotation to undertake the assignment. We have those sort of forms in each of our products. So here's the form, which has details that you can obviously edit if you're not going to do some of that work, but it goes through and works through the whole process, so you can supply an estimate if you wish to your client for the work that's going to be undertaken. So you can work through and calculate your time. If we go back to the procedure form now, there's an assignment control form to help you through. There's a list of forms that you might make available to a client to give them a better understanding of what this is all about. We've got frequently asked questions. Again, you would badge that and send it to your clients. So this form would explain some of the operations of this legislation for the benefit of your clients, so they have a better understanding of the legislation. There's other items there on implications for businesses and 10 myths of the PPSR. There's some videos which have been produced by PPSA Protection, a company owned by a private individual, Rick Nash, who was so annoyed at the lack of an education program by the government on the PPSA that he produced some material on a website himself. And then we have the main form, which is the control form. Which is going to prompt you to analyze all aspects of what's going on in the client's businesses. So the first thing is stock. We've broken stock into its components because people tend to forget. They forget they've got consignment stock somewhere. They forget they've got demonstration stock somewhere. They just might be thinking of the stock of goods. And very importantly, you then need to understand where it's located, because at least 50% of the court cases have been over property situated on someone else's property. So, and I should have said stock or an asset situated on someone else's property. So if it's on your own, the client's own premises, there's virtually no problem. But it's when it's on leased premises or someone else's property or on consignment, the potential problems arise. So there's some further questions there that you could then look at. Are there any concerns? Then you need to go through if they're in a farmer, in livestock on adjustment. Livestock on adjustment's causing a lot of concern. There's massive droughts in most of Australia at present, and a lot of cattle have been moved and placed on someone else's property. I think they should be lodging registrations on the PPSR. We've included thoroughbred horses because there's been an infamous case in New Zealand where a syndicate that owned a very valuable racehorse worth over $2 million lost it under the New Zealand equivalent of this legislation. Crops have got some special treatment in the legislation because obviously once the grain goes to a silo, it's been mixed with other producers' products as well. Then you can look at the goods that have been supplied. There's all different activities. Consignment type of things can cover artist work, so we've included that so you think about it. Your painting, sculptures, designed, and a lot of that then gets back to whether the artist is a amateur, someone who just does it for a hobby, or whether they are professional. And it's mainly obviously the professional type people that have been caught up under this legislation. Plant and equipment, construction equipment has caused a lot of problems already. Tradesmen's scaffolding, where is it, and so on. Then we start getting into the leases. The real problem is leases for indefinite period, and leases of a term of more than 1 year, and leases of up to 1 year automatically renewable. They need to be considered because they are not protected unless they're registered on the PPSR. Motor vehicles at this stage, the rules are on a 90-day basis. As I said earlier, the House of Representatives has passed an amendment to change that to 1 year for motor vehicles so that they will be treated the same as anywhere else. We copied New Zealand in this legislation. I don't know why, but then we changed some things, and that was one of the changes, bringing in 90 days instead of 12 months. So yeah. I don't know whether anyone really sat down and looked at the downside of this legislation in the government of the day, because it's causing a lot of headaches. So you've got motor vehicles, then you've got other assets where they've got serial numbers, boats, aircraft, all need to be thought about. So we've detailed them like this so that it will prompt you to ask those questions. You might have forgotten that a client's got an aircraft that they use in their grazing industry. And where is it? Who's using it? Whose property is it situated on? Because if assets happen to be situated on an indefinite arrangement on someone else's property and an insolvency event occurs, your client that owns that asset's got real problems. Debtors gets back really to the retention of title clauses. There's a new term being introduced under this legislation called accession. That really covers where you might have a client in the steel fabricating industry that makes a staircase that then is bolted and welded onto some other item within a mine or a factory. Under the old Ramalpa type rules, you couldn't have repossessed that, but there is some protection for that type of transaction under this legislation. One of the few good points, I think, from a small business point of view. Licenses and trademarks can also be caught up in this legislation. So this is one of the reasons we believe you need to do the due diligence review. Sit down and have a good look at what's going on in your client's business. Have they placed the licenses or trademarks or intellectual property into another subsidiary company so that they can effectively market it? And is that entity borrowing money? Therefore, it could mean that that asset could be seized. Loans can also get caught up. So that's the type of information that we're suggesting you look at. There's about 22 different items contained in there, and they're summarised here because this main procedure control form is asking you to tick that you've looked at these, and some of them you'll answer no because you're not going to do it. There's then steps to look at completing the review. So we'll just skip through on these. The first question then is the retention of title clause. Has it been reviewed by a solicitor since January 2012? Then we go to the terms of trade agreement, the security agreement. And obviously what you're trying to ascertain out of this is if there's something that looks a bit odd, is it something that should be registered? $8 to register for 7 years. It's a pretty cheap insurance policy. And really that's where this falls, I think. It's risk management for your clients. Then we're suggesting that there should be some consideration of a due diligence on the customers of your client. Because I mentioned before this financial risk amount. What can your client accommodate? And bad luck normally runs in a series, so just remember your client might be unlucky enough to strike a few problems at literally the same time. So our recommendation in our forms here is that your client would be estimating for every customer what the level of trade might be. So if the customer's selling someone $10,000 worth of product a month, I think they should be doing a calculation and saying, well, before we really did something about it, they may have got out to 90 days. After all, the average debtors days outstanding in Australia is currently 53 days. There's plenty of businesses a lot higher than 53. So it might be 90 or even 120 days. You say, well, they may have run up the account before our client really took action. So what amount would they then cover? Is that exceeding their financial tolerance amount? It could be, in that instant I just gave you, 30 grand or $40,000. And if so, our recommendation is that that client would be registered on the PPSR. You don't have to do it for every invoice. You do it once. And as long as the relationship, the transactions your client's doing don't change, you don't have to go back and do anything else about it, other than in 7 years' time when you'll need to redo all this. Because if you've only taken the $8 option for the 7-year period. So that's basically what these forms are about. They're working through, they're posing questions for you to pose to your client to then follow through to see what the client's position should then be. Our recommendation is that you would conduct these type of reviews, if you haven't done them already, as soon as possible. In our material there is a letter to send to clients that decline, so that you get them to sign that off and get a copy of that back, that they don't want you to undertake a review. In the unfortunate event that in a few years' time they do have a problem and they are not very happy with the advice they may have got from various people, including you, so you can protect yourself to say, we advise you to do this, you declined. But our suggestion is that you would then be saying to your client that you want to undertake this type of review every 6 or 12 months, because things will change in a client's affairs. The person that you mentor in this initial review will leave and be replaced by another person who doesn't understand what's going on and doesn't follow through. And sure, it's going to cost the client $350, maybe $1,000 a year in extra fees, and every 7 years $8 to register. But it's a fairly cheap insurance cost when you look at some of the problems that are emerging in the marketplace, both in Australia and New Zealand. We are currently preparing a new series of articles based on these court decisions, and they will be part of the package. If you subscribe and pay the $299 or register on ESS BIZTOOLS for a gold package, you will receive all new material that we add to the personal property securities register component over the next 12 months. So that will be including the articles we're preparing on the court cases, and we are in the process of implementing comments back in to the template, the checklists on the court cases for those industries. So for argument's sake, the ones that we've mentioned here today of inventory, heavy moving equipment, water tanker, cabinet making, etc., will all be reflected in the commentary we've written. We also have checklists for 17 separate types of businesses: retailer, wholesaler, manufacturer, and that list will grow. What we're doing at present will have about 20 of those types of businesses specifically mentioned in our system by the end of next week. A subscriber will continue to get the benefit of that new material as we add to it, and obviously we're going to be closely watching all court cases and updating our material based on the rulings that the courts make on this legislation. So in summary, we believe it's very important that accountants play a very proactive role in this area to assist clients to avoid the pitfalls of this legislation. I cannot believe that these pitfalls were intended to be there as such. I'm sure that various people within government and their advisors are quite surprised. I can only believe that the bureaucracy assumed that every business would read this legislation and clearly understand it and would lodge their registrations on time. Unfortunately, that has not happened, and I don't think it would have ever happened without a massive education program. At this stage, the government's elected not to have an education program, but we've got businesses that are potentially going to fail because of this legislation. Therefore, I would urge you as the accountants for your clients to be very proactive in regard to this whole legislation and conduct these due diligence reviews. And we would therefore respectfully offer you our system as a way of undertaking those reviews. Obviously, if you can do it some other way, please do it. Just help your clients to survive these problems. So I'm just going to check now. I did check before and I didn't see that there were any questions. If you think of any questions later that you'd like answered, please send us an email. This webinar has been part of a series. You can receive the earlier webinars on the PPSR if you wish. Just send us an email and we will send that to you. And we will be sending you a link to the email from this webinar tomorrow afternoon. And if you wish to share the webinar with your colleagues in your firm, please do so. Once again, don't forget the special offer, $299 including GST. You receive all the material that we have produced on the PPSR, and hopefully in that way you will avoid having a very difficult conversation with your clients at some time in the future. Thank you very much for participating in this webinar today. Have a wonderful day. Goodbye.